Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Oklahoma v. Environmental Protection Agency. In this case, the court considered this issue. Does the U.S. Court of Appeals for the District of Columbia have exclusive jurisdiction to review an Environmental Protection Agency action that affects only one state or region, simply because the EPA published that action alongside actions affecting other states in a single Federal Register notice? The case was decided on June 18, 2025. The Supreme Court held that the Clean Air Act requires that EPA State Implementation Plan (SIP) disapprovals be reviewed in regional circuit courts rather than the D.C. Circuit when they are locally or regionally applicable actions not based on determinations of nationwide scope or effect. Justice Clarence Thomas authored the 6-2 majority opinion of the court. The court applied a two-step framework established in EPA v. Calumet Shreveport Refining to determine proper venue under the Clean Air Act's venue provision. First, courts must identify the relevant EPA action and determine whether it is nationally applicable or locally or regionally applicable. An action under the statute means a particular exercise of EPA authority undertaken pursuant to a particular Clean Air Act provision, determined by reference to the underlying statutory provision rather than how EPA presents its decision. Here, EPA's disapprovals of Oklahoma's and Utah's state implementation plans constitute separate actions, because the Clean Air Act treats individual SIP approvals and disapprovals as discrete actions under Section 7410. Each SIP disapproval applies only to the specific state that proposed the plan, making them locally or regionally applicable actions, the prototypical example of such actions under the statute. Because the SIP disapprovals are locally or regionally applicable, the court proceeded to the second step, determining whether the nationwide scope or effect exception applies to require D.C. Circuit review. This exception requires that EPA's action be based on a determination of nationwide scope or effect, and that EPA find and publish this basis. Although EPA made the required finding, the court held that EPA's disapprovals were not actually based on determinations of nationwide scope or effect. The exception applies only when a justification of nationwide breadth is the primary explanation for and driver of EPA's action. Here, EPA's disapprovals resulted from predominantly fact-intensive, state-specific analysis of each SIP's contents, producing unique lists of deficiencies for each state. The four nationwide determinations EPA cited, including use of updated modeling and a 1% contribution threshold, were merely analytical tools that aided EPA's review rather than primary drivers of the disapprovals. Justice Neil Gorsuch authored a concurring opinion, joined by Chief Justice John Roberts, agreeing with the judgment but following a different analytical path as explained in their dissenting opinion in a companion case, Environmental Protection Agency v. Calumet Shreveport Refining, LLC. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Petitioners seek judicial review of the Environmental Protection Agency's, EPA's, disapprovals of two state emissions control plans. These cases require us to decide the proper venue for their challenges. The Clean Air Act, CAA, channels these challenges to the U.S. Court of Appeals for the D.C. Circuit if EPA's disapprovals are nationally applicable, and to a regional circuit if they are locally or regionally applicable. But the CAA contains an exception for certain locally or regionally applicable actions based on a determination of nationwide scope or effect, which also must be brought in the D.C. Circuit. Applying the interpretation of Section 7607b, 1, that we outlined today in EPA v. Calumet Shreveport Refining, LLC, we hold that EPA's disapprovals are locally or regionally applicable actions reviewable in a regional circuit. The CAA's venue provision, Section 7607b, 1, dictates where petitioners should challenge EPA actions taken under that statute. This provision enumerates certain nationally applicable actions that must be brought in the D.C. Circuit, and certain locally or regionally applicable actions that must be brought in a regional circuit. It then provides catch-all clauses requiring the same treatment of all other nationally applicable and locally or regionally applicable actions. But, Section 7607b, 1, includes one exception to its default rule for locally or regionally applicable actions. A challenge to such an action belongs in the D.C. Circuit if, 1, it is based on a determination of nationwide scope or effect, and 2, in taking such action EPA finds and publishes that such action is based on such a determination. In Calumet, we explained that determining venue under Section 7607b, 1, requires a two-step inquiry. At the first step, we identify the relevant EPA action and ask whether it is nationally applicable or only locally or regionally applicable. If the action is nationally applicable, then any challenge to it belongs in the D.C. Circuit. But if the action is locally or regionally applicable, then we proceed to the second step, where we ask whether the nationwide scope or effect exception applies to override Section 7607B, 1's default rule that locally or regionally applicable actions are reviewable only in the regional circuits. If the exception applies, then any challenge to the action must be brought in the D.C. Circuit. These cases arise from EPA's review of state implementation plans, SIPs, i.e., state proposals for how to comply with an EPA National Primary or Secondary Ambient Air Quality Standard, NOx. The CAA makes the SIP process one of federal-state collaboration. EPA first sets a NOx, which represents the maximum airborne concentration of a pollutant that the public health can tolerate. But states bear primary responsibility for deciding how a NOx should be attained. States must propose SIPs that provide for the implementation, maintenance, and enforcement of a NOx within their jurisdictions. EPA then approves or disapproves each SIP based on whether it meets the applicable requirements of the CAA. If EPA disapproves a SIP, then EPA must issue a federal implementation plan for that state within 2 years. A state can avoid this outcome only if it corrects the deficiency and gains EPA approval for its revised SIP before EPA promulgates the federal plan. In 2015, EPA triggered the SIP process by revising the NOx for ozone to be more stringent. Each state in turn submitted a SICP, which, as relevant here, detailed how the submitting state would comply with the CAA's Good Neighbor provision. That provision accounts for the externality that because air currents can carry pollution across state borders, emissions in upwind states sometimes affect air quality in downwind states. In particular, the provision requires SIPs to contain adequate provisions, prohibiting in-state emissions activity that would interfere with other states' NOx compliance. EPA ultimately disapproved 21 states' SIPs for failure to comply with the Good Neighbor provision. These states had all asserted in their SIPs that they did not need to propose new emissions reduction measures in light of the new NOx. But, after considering the contents of each individual state's submission, on their own merits and making an individual determination with respect to each SIP, EPA disagreed. After making its individual determinations, EPA aggregated its disapprovals into one omnibus Federal Register rule. The rule began by describing EPA's four-step framework for evaluating SIP submissions, although EPA noted that it had also permitted states to present alternative approaches. EPA then provided for each state a brief, high-level overview of its evaluation and key bases for disapproval, while directing readers to the relevant Federal Register notifications of proposed disapproval for each state and certain other documents for the full basis for the EPA's disapprovals. In its rule, EPA also asserted that its disapprovals would be reviewable only in the D.C. Circuit. According to EPA, the rule was a nationally applicable action under Section 7607B, 1. Alternatively, EPA made a finding that, if the rule was only locally or regionally applicable, then it fell within the nationwide scope or effect exception. EPA identified as qualifying determinations of nationwide scope or effect its use of the same, nationally consistent four-step framework, as well as its evaluation of states' alternative approaches with an eye to ensuring national consistency and avoiding inconsistent or inequitable results. Disregarding EPA's conclusions, states and energy industry petitioners challenged EPA's SIP disapprovals in the regional circuits. EPA moved to dismiss these challenges or to transfer them to the D.C. Circuit, but its efforts have been largely unsuccessful. Of the 5 circuits to resolve EPA's motions, 4 have found that regional circuit review is proper. Only the 10th Circuit disagreed, granting EPA's motion to transfer suits brought by the states of Oklahoma and Utah and by industry petitioners, collectively, petitioners. In its view, EPA's omnibus rule disapproving the 21 SIPs constituted a single, nationally applicable action. Rejecting petitioners' contention that each individual SIP disapproval constitutes its own action, the 10th Circuit concluded that the relevant action is simply whatever EPA has chosen to issue. Thus, because EPA had grouped its disapprovals into a single rule, that rule constituted the action at hand. And, the 10th Circuit concluded, this action was nationally applicable given both its geographical breadth and the nature of its analysis. EPA's rule covered 21 states across the country and reflected EPA's application of a uniform statutory interpretation and common analytical methods. The 10th Circuit accordingly transferred petitioners' challenges to the D.C. Circuit. We granted certiorari to review that transfer decision. Applying our Calumet framework, we begin with the first step of the Section 7607B, 1, inquiry. As explained, at this step, we must identify the relevant EPA action and then decide whether it is nationally applicable or only locally or regionally applicable. We conclude that the EPA action in these cases is not EPA's omnibus rule, but rather its individual denials of the Oklahoma and Utah SIPs. Clearly, these denials are locally or regionally applicable. As we recognized in Calumet, because Section 7607b(1) pegs venue to the scope of the EPA action being challenged, our threshold task is to identify the action at issue. Only when we understand the relevant action can we decide whether it is nationally applicable or locally or regionally applicable. That is, whether it facially applies throughout the entire country, or only to particular localities or regions. Here, as in Calumet, our resolution of the threshold question effectively resolves the proper classification. An action under Section 7607b(1) is a particular exercise of EPA authority undertaken pursuant to a particular CAA provision. We thus determine the relevant action by reference to the CAA provision under which EPA has acted. This focus on the operative CAA provision means that the relevant action will not necessarily track how EPA has presented its decision. For example, in Calumet, we held that, whenever EPA denies a small refinery's petition for an exemption from the CAA's renewable fuel program, each individual exemption denial constitutes its own action, because Section 754509b defines EPA's role, evaluating a petition and acting on it, on a petition-specific basis. That statutory denomination controls even if EPA chooses to resolve multiple petitions in one fell swoop, as it did in Calumet. Here too, we conclude that each EPA SIP disapproval constitutes its own action. We therefore reject EPA's contention, adopted by the 10th Circuit, that EPA's omnibus rule should be treated as a single action. Instead, we have before us two distinct actions, EPA's respective disapprovals of the Oklahoma and Utah SIPs. Section 7607b(1) simplifies our analysis of this issue. The CAA enumerates an individual SIP approval as an example of a locally or regionally applicable action, unlike in Calumet, where we dealt with an EPA decision that did not fall within any of Section 7607b(1)'s enumerated actions. Section 7607b(1) provides a petition for review of the administrator's action in approving or promulgating any implementation plan under Section 7410 of this title, other enumerated examples, or any other final action of the administrator under this chapter, including any denial or disapproval by the administrator under Subchapter I, which is locally or regionally applicable, may be filed only in the United States Court of Appeals for the appropriate circuit. ACFEB is an implementation plan under Section 7410 and Section 7607b(1) in referring expressly to EPA's action in approving any implementation plan under that provision, makes clear that each EPA SIP approval is its own action. It follows that each EPA SIP disapproval is also its own action. EPA undertakes SIP disapprovals pursuant to the same CAA authority underlying its SIP approvals. Namely, Section 7410 directs each state to adopt and submit to EPA a plan for NOx implementation, and in turn directs EPA to either approve such submittal or disapprove it. Thus, EPA's approvals and disapprovals are opposite sides of the same coin. As Section 7410's SIP-specific focus makes clear, and Section 7607b(1)'s enumeration confirms, the CAA treats both individual SIP approvals and individual SIP disapprovals as discrete actions. Thus, we have before us two EPA actions, EPA's disapprovals of the Oklahoma and Utah SIPs. These two disapprovals are undisputedly locally or regionally applicable actions. A SIP is a state-specific plan, so an EPA disapproval on its face applies only to the state that proposed the SIP. And the CAA recognizes this limited scope in enumerating a SIP approval as a locally or regionally applicable action. If anything, EPA's decision on an individual SIP is the prototypical locally or regionally applicable action, as courts have recognized and even EPA acknowledges. EPA's and the 10th Circuit's contrary arguments do not survive scrutiny. EPA largely reprises the arguments it made in Calumet, and we reject those arguments for the reasons explained there. In short, Section 7607b(1) makes the CAA's framing of the relevant action controlling, regardless of how EPA chooses to package its decisions in the Federal Register. Thus, although EPA was free to aggregate its SIP disapprovals into one rule, that aggregation has no significance for venue purposes. The 10th Circuit's endorsement of EPA's position is equally unpersuasive. On its view, we must accept EPA's framing of the relevant action because EPA's action is just whatever it has chosen to issue. But that reasoning fails to grapple with what Section 7607b(1) means by that word. In context, Section 7607b(1) defines the relevant action by reference to the underlying CAA provision, not EPA's stylization. Nor can the 10th Circuit deem EPA's actions nationally applicable based on EPA's use of a uniform statutory interpretation and common analytical methods. The applicability of an action turns on its formal geographical scope. An action applies nationally only if, on its face, it has binding effect throughout the country. In contrast, EPA's interpretive and analytical methodology goes to its underlying reasoning. That component matters only at the second section 7607b(1) step, where one prerequisite for DC Circuit review is that a locally or regionally applicable action nonetheless be based on a determination of nationwide scope or effect. We would make a hash of the CAA's venue framework if we look to the basis for EPA's actions at the first step too. Because EPA's SIP disapprovals are only locally or regionally applicable, we move to the second step of the section 7607b(1) inquiry. At this step, we ask whether the nationwide scope or effect exception applies to override the default of regional circuit review for locally barring regionally applicable actions. We hold that it does not. The exception does not apply here, so these cases properly belong in a regional circuit. Our analysis turns on the first of the nationwide scope or effect exception's two requirements. That exception applies only if the action at issue, 1, is based on a determination of nationwide scope or effect, and 2, in taking such action, EPA finds and publishes that such action is based on such a determination. Here, the second requirement is plainly satisfied. EPA included in its Federal Register notice an express finding that its SIP disapprovals were based on a determination of nationwide scope or effect. Thus, our task is to decide whether that finding was correct. We hold that EPA's SIP disapprovals were not based on any determination of nationwide scope or effect. As we explained in Calumet, this requirement is met only if a justification of nationwide breadth is the primary explanation for and driver of EPA's action. But, such a justification does not rise to this level if EPA also relied in significant part on other, intensely factual considerations, or if the key driver of EPA's action is otherwise debatable. EPA's disapprovals of the Oklahoma and Utah SIPs fall into the latter category. EPA's omnibus rule makes clear that its SIP disapprovals were based on a number of intensely factual determinations particular to the state at issue. As EPA explained, it evaluated the contents of each SIP on their own merits, considering the facts and information available to the state at the time of its submission, as well as more recent information regarding that state's circumstances. From this state-specific analysis, EPA produced for each state a list of bases for disapproval, with each list giving a unique mixture of reasons. For example, as to Oklahoma, EPA rejected its attempt to disclaim responsibility for certain emissions in Texas, while also faulting it for providing an insufficient evaluation of additional emissions control opportunities. And, as to Utah, EPA found that the state had inadequately justified its attempt to discount certain emissions in Colorado, while also finding technical and legal flaws in the state's arguments regarding various emissions considerations. Based on these and other reasons, EPA concluded that each state had failed to submit a SIP with the necessary provisions to eliminate emissions consistent with that state's good neighbor obligations. This state-specific analysis contrasts sharply with EPA's justifications in Calumet, where we found the nationwide scope or effect exception triggered. There, EPA made two determinations that applied uniformly to all small refineries across the country, which it used to reach a presumptive conclusion as to how the exemption petitions before it should be resolved. EPA considered refinery-specific facts only to confirm that it had no reason to depart from its presumptive disposition. In that circumstance, we explained, EPA's national determinations constituted the most important parts of its reasoning and the primary driver of its decision. Here, in contrast, no nationwide factor all but settles EPA's ultimate decisions. Instead, EPA disapproved Oklahoma's and Utah's SIPs after conducting predominantly fact-intensive, state-specific analysis. The determinations that EPA proffers as the basis of its disapprovals only reinforce this conclusion. Before this court, EPA points to four determinations. 1. Its use of updated, 2016-based modeling as the primary basis for its assessment of air quality conditions and pollution contribution. 2. Its application of a 1% contribution threshold across all states to assess whether a state contributed more than a de minimis amount of ozone pollution downwind. 3. Its determination that the relative contributions of other states or countries could not excuse a state from analyzing whether its own emissions significantly contribute to downwind non-attainment. And 4. Its position that an upwind state cannot rely on emission reduction measures that are not actually incorporated into its state plan. We agree with EPA that these conclusions qualify as determinations of nationwide scope or effect, in that they are conclusions that apply nationwide, either formally or as a practical matter given EPA's rejection of alternative approaches. But these conclusions are at most heuristics that aided EPA's analysis, as opposed to the primary drivers of its disapprovals. None of these determinations, either alone or in combination, makes clear why EPA concluded that Oklahoma and Utah had produced inadequate proposals for compliance with their good neighbor obligations. Take, for example, EPA's use of the 1% contribution threshold. This threshold, which is triggered whenever an upwind state contributes at least 1% of the permissible ozone level to a downwind state, refers to EPA's measure of when an upwind state becomes linked to a downwind air quality problem, so as to implicate potential good neighbor obligations. EPA used this threshold only for screening purposes. Where the threshold was triggered, EPA would further evaluate the upwind state's emissions to assess whether those emissions require ameliorative steps under the CAA. But this kind of analytical guidepost cannot be deemed the primary driver of EPA's ultimate conclusion that Oklahoma's and Utah's SIPs were deficient. As EPA does not dispute, even after it made its threshold determination, there was still a lot of work to be done before EPA could issue its disapprovals. In that circumstance, we cannot say that the nationwide scope or effect exception applies. The 10th Circuit erred in holding that petitioners' challenges should be reviewed in the D.C. Circuit. EPA's disapprovals of the Oklahoma and Utah SIPs are locally or regionally applicable actions. And these cases are not ones where the nationwide scope or effect exception applies. Accordingly, as with most locally or regionally applicable actions, petitioners' challenges can be heard only in a regional circuit. The judgment of the Court of Appeals is reversed, and the cases are remanded for further proceedings consistent with this opinion. It is so ordered. Justice Alito took no part in the consideration or decision of these cases. Justice Gorsuch, with whom the Chief Justice joins, concurring in the judgment. The court holds that the proper venue for this litigation lies in an appropriate regional circuit, not in the D.C. Circuit. I agree. As I explain in today's companion case, however, the court and I arrive at that conclusion by different paths. Accordingly, I am unable to join the court's opinion, but I am pleased to concur in its judgment. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.